I'm going to transition away from paid family medical leave into wage and hour issues. First, I'm going to talk about federal issues under the Fair Labor Standards Act, and then I'm going to handle a few issues arising under the Massachusetts Wage Act. When some of you see this title, DOL Proposed Regulations, you might have some flashbacks, some shudders to a couple of years ago. I'm sure a lot of you worked very hard to bring your companies into compliance with updates to the salary level test a few years ago, and then found out that it was not going to come into effect. Well, a few years later, there might be some new regulations that are coming down the pipeline. We just wanted to make you aware of them. Starting at the most basic, the federal statute on point is the Fair Labor Standards Act, known as the FLSA. It requires that all employees, unless they're subject to an exemption, are paid a minimum wage and overtime pay. Overtime pay is known as time and a half. It's a premium rate, 1.5 times the regular hourly rate for every hour worked more than 40 in a given work week. That applies to all non-exempt employees. So I'll quickly address what makes an employee exempt. In order for an employee to be exempt under the FLSA, they must meet a 3-pronged test. That's set forth in painstaking detail in the DOL regulations. I'm going to try and simplify it. There's 3 prongs to the test. The first is the salary basis test. That means that the employee must be paid a fixed and predetermined amount that does not depend upon when the employee is in the workplace. If the employee is ready, willing, and able to work, then they must be paid for that time to fit under the salary basis test. The second is the salary level test, meaning that there must be a threshold met in terms of the remuneration to the employee through a salary. And then the third is the duties test, meaning that the employee's primary duties must be of an exempt criteria. Those are typically known as the white collar exemptions, the professional, administrative, or executive exemptions. There are several others under the FLSA. Those include computer sales, computer as well as outside salesperson. There are about 20 to 25 different exemptions under Massachusetts law as well, and some of them are as I guess difficult to decipher as you work for an educational institution. So yeah, you need to be careful about that, who's exempt versus non-exempt. So the proposed rulemaking that the DOL has come up with, the DOL is responsible for enforcing the FLSA, relates to the salary level test. In 2004, the salary level test was set at $455 per week. Extrapolating that over a 52-week year, it's $23,660 per year. So that meant that any employee that earned less than $455 per week in salary was non-exempt, and that was regardless of his or her duties. In 2015, the Obama administration's Department of Labor proposed increasing the salary level test to a rate of $913 per year, or $47,476 per year, and that was scheduled to become effective in May 2016. It was eventually pushed back to December of 2016. Basically, it was doubling what the salary level test was, and that was probably why a lot of you were looking at your workforce and seeing some employees who had easily cleared the salary level test who are no longer meeting the salary level test, and probably worked with a few of the lawyers in our office to address that. Hope you saved your notes. Now, within a few weeks before this was going to take effect, the federal court, a federal district court in Texas, enjoined the proposed salary level test. They entered an injunction preventing the Department of Labor from enforcing that. It was never implemented. The election in 2016 led to the administration going a different direction, obviously. So as we sit here today, the salary level test is still at the 2004 level, $455 per week, $23,660 per year. Within the last few months, the Trump administration's Department of Labor has filed a notice of proposed rulemaking to raise the salary level test. You'll notice that while the Obama administration proposed raising it by about $24,000 per year, this is roughly $12,000. So it's basically about 50% of what the initial rulemaking was back in 2016. So this proposed rule would raise the weekly salary level test to $679 per week, or extrapolated over a 52-week year, $35,308 a year. So it's about half of what was initially intended back in 2016. While the 2016 change was going to affect millions and millions of employees, this will only affect 1 million workers, make 1 million workers now eligible for overtime premium pay. And potentially some of your employees will be impacted. In 6 days, a public comment period that the DOL is required to have under federal law will close. Stakeholders, lobbyists will be providing their input as to whether they agree or disagree with that rate. You're welcome to check it out. That's why we've provided the link if that's of interest to you. There are a few additional proposed changes as well that I wanted to highlight for you. The first relates to highly compensated employees. Under the Department of Labor regulations, highly compensated employees have a relaxed duties test. The idea being that if an employee is making a certain level of earning a certain level of pay, then the DOL does not need to scrutinize whether their duties are exempt as highly. So the highly compensated employee's salary level is going to raise from an even $100,000 to an uneven $147,414. So if you have employees that are exempt under the highly compensated exemption, then you'd want to look at their duties if they're between the $100,000 and the $147,000 to make sure that under a relaxed duties test, they'll still be exempt. Otherwise, they might be non-exempt and eligible for overtime. The Department of Labor is also committed to a periodic review of the salary level test to make sure it goes up as the cost of living increases. Previously in 2016, the Department of Labor proposed automatic increases as time goes on. This is just I would say, nebulous commitment to look into it periodically rather than tying it to any sort of cost of living or any formula. And finally, there's going to be some flexibility relating to the salary basis test, allowing 10% of the salary level to be satisfied by non-discretionary bonus and incentive payments. So that's to give employers some flexibility.